Please be seated. Members of the jury, if you would now please give your full attention to Mr. Leary as he makes a closing argument on behalf of the defendant, Mrs. Ali.
Okay. Ladies and gentlemen of the jury, thank you. In the aftermath of October 18th, 2024, Zahraa Ali, in the parking lot, alone, sitting in her husband's truck, had to think to herself, how did I get here? Just 24 hours before, she's planning a trip to go to Iraq to see her sister. Her daughter, Fatima, told you, Mom can be lonely. It can be hard. She missed her sister. She was worried about me. School wasn't going well. I had left Timberline. I was in homeschool, or not homeschool, online school. Clearly, there was conflict with the choices that she was making. She had previously run away. This was my client's last gasp attempt. I have a 17-year-old daughter. Mere months till she's 18. This is my last chance where I have the ability to parent my daughter, hopefully get her in the right direction. Go to Iraq, bring her sister, bring her brothers, spend time with family, be away from dad, continue with school, and hit the reset button. Little did she know that there was another plan afoot. The alarm that would go off at 4 o'clock in the morning that wouldn't wake up the 6-year-old brother. Her third daughter would quietly go downstairs, sneak out the back door into the dark with $100 that she had taken from her mom's purse. No job, no cell phone, no place to go. Apparently had never even told her boyfriend what she was going to do. These are the rash decisions that every parent fears. You want to protect your kids from danger, as the prosecutor acknowledged in closing. It's a tough job. It can suck. You worry, you hope, you pray that they do the right thing, and that when mistakes are made, that they're not devastating, that the child can learn from them, and when they emerge into their 20s, into their late 20s, you can look back, laugh, and cry, and be grateful that you're still together. I'm reminded of the story in jury selection that I think you were all there for, when the guy's talking about his daughter who ran away on a horse. And I asked him, well, where's she now? Oh, she lives next door. That's what one could hope for. But instead, the night of October 14th, or the late afternoon of October 18th, she's sitting in the car. Despite all of her efforts to track down and protect her daughter, she lost her daughter. We're not going to Iraq. I don't know what's going to happen to my daughter. I certainly don't know what's going to happen to my husband. What she didn't know at that point, she only knew that this was half the story. The freight train was coming. The vice, the state, put her in his target. And that's why I'm here. That's why she's here. And that's a piece of why you're here. So, as we look through the evidence, I think it's important to think about the difference of perspective of what my client saw, what my client knew, not just from the witnesses, but from what the video shows. So I'm going to start with the inner city transit bus, Exhibit 38. Maybe. Unplug it and plug it back in? Oh, well. I'm gonna unplug it and plug it back in. Okay. Okay. Intercity transit bus, Exhibit 38. So we've heard a lot of descriptions as to where people are, what they're doing. We know definitively, as we piece this together, where my client was at the start of this. What did I say? Sorry, Exhibit 34. Okay. So now hitting play.
Can you indicate
At-
the time, please?
Yep, at hitting play at 2:13:08. And this is just a clip, and we see it stop at 2:13:14, and we see the silver and black or silver and blue Honda Element that we will now know contains Haneen Ali and Zahraa Ali. Now we also know that at the approach of this, that the conflict between, the physical conflict between Mr. Ali and Isaiah Williams has not happened. So when she drives by on Mullen Road, she potentially saw her daughter, her husband, Isaiah, but there had been no physical confrontation at that point. There we go. Plug it on, plug it in. Okay. Well, here's what I can do. I can talk you through it. Okay, so we see the intercity transit bus. We know that they're approaching. At 2:14, we see the Honda Element come in. And we know, from what I just showed you and the other exhibits, and you'll be able to watch on your own, is that none of the physical confrontation has occurred. So she has no knowledge as to any physical altercation outside of the bus. There we go. Okay, so we now have seen Exhibit 34 up until 2:14. So we know that the bus is passing her in the turn lane at 2:14, and she is then about to turn in behind the bus. How do we know that? We know that from Exhibit 14, and that is the parking lot surveillance video that shows the bus on Mullen Road and the arrival of the Honda Element. So there we see it turning in behind the bus. And we will see, or not, when you watch it back, when you're deliberating, you will see her run through the parking lot. And the time it takes to go from when the car turns in, and you can time it up to when the fight occurs. to then running across the parking lot and to when she arrives. Okay, so in terms of this discussion about what other witnesses see and what they describe, none of that is she's privy to. She doesn't see the punch. She doesn't see the punches to her husband, the kicks, at least initially until she arrives. All right, so we're going to try something different. And we're going to try to go to Exhibit 34. And this will just take me a second to load up. So, when we talk about what Exhibit 34 shows, it is something that I anticipate that you're going to spend a considerable amount of time. Because, fortunately for my client, in 2025 and 2024, we have surveillance video, and we're not relying on the testimony of eyewitnesses. Because, as has been on full display in this case, eyewitness testimony be all over the map in terms of what people saw, what they perceived, versus what actually happened. When we Another shot. Okay, so now I have Exhibit 34 up on the screen. Now, as we work through it, we are all in agreement.
Can you indicate what time you have about
Yep.
these things?
So at 2:13:56, we see Mr. Wagner walking across the street. We know a significant amount of physical activity has occurred in terms of Mr. Ali being punched, the dragging, and the bus driver getting out of the bus and coming to the aid, frankly, of Mr. Ali and his daughter. Now, hitting play. Okay, so now we are at 2:13:59. What we see right here, well, I don't know why I use technology. Okay, what we see here is we see Mr. Wagner. We see the individual in the beige sweatsuit, okay? Right above his left shoulder, you can see the head of my client. And Zahraa Carter, sweatsuit, oh my goodness. We could see Josh Wagner. Now, Your Honor, can we take a 5-minute break?
Yes, we can. Members
I did
of the
try this
jury, I'm going to
before.
ask the bailiff to take you back for hopefully just about a 5-minute break. All right, we'll be in recess for 5 minutes.
Thank you, Your Honor.
Hopefully.
It's been working while you were gone.
Okay.
Before, I think it's allergic to the jury.
Bring the jury in, please. Please be seated. All right, Mr. Leary, you may continue.
Thank you for your patience. Thank you for being here. You might be surprised I am somewhat averse to using technology, and this only confirms that. Okay, so if we can have the screen. Did work in your absence. Okay, all right, so we have the screen, Exhibit 34, at 13:57, zoomed in, and we see Josh Wagner, his truck crossing the bike lane white stripe, and you will see my client emerge from screen right by the tree, and I'm going to work my way through. So you can see, as I'm going frame by frame, you can see her now walk in front of the tree and extend her hands out. And you can see Isaiah, his hand and face slightly above the bus driver. And we see Mr. Wagner go down. And we are at 14:01, frame 3, and you will see my client then begin to step back. Okay, so we are at 14:04, frame 6. And what you can see is you will see the camo hat of Mr. Wagner. You see the individual in the beige, orangish sweatsuit, male with the backpack. And over his right shoulder, you will see my client standing to get out of the way of Mr. Wagner as he prepares to go down. Moving frame through. Mr. Wagner then goes down. We are at 2:14:07, and you can still see my client. She's very clear here, standing above the right shoulder of the individual in the beige sweatsuit. She is standing as Mr. Wagner goes down to intervene. So now I'm going to go back to 2:14:07 and hit play. We see Isaiah walking around. We see him momentarily start talking with Haneen. Haneen is filming him. He's upset, threatens to punch her, and that's at 2:14:36 as I stop it, okay? So we see Zayla Carter and take him away from Haneen as I hit play again. You can see the bus driver just standing around. So we're now at 2:14:49. And we see Isaiah standing up by the tree. We see the third individual, the third adult that's never been named, in the blue rain jacket and a beige hat. We see Wagner sitting with his hand on Mr. Ali's head, and the situation appears to be calm. So now, if we look at the testimony of witnesses as to what they described what my client did. The situation was over. She didn't appear to be at risk. If she was, I would have brought her onto the bus. Josh described the mom screaming and crying. She didn't get in my way. She didn't impede. Elijah, I didn't see the adult females. Eric, she just looked like she was watching from the looks of it. Caleb, question, did you see Zahraa Ali attempt to get people not punching her husband in the head? Not that I'm aware. Athena, the person whose arm was under the neck and the person yelling, my husband, do you know who that was? I'm not sure anymore. Now, what's interesting is in the state's closing argument, they said that I asked a confusing question and I was the one that elicited that response. I actually watched it last night and went back. It was actually on redirect from Ms. Zoe. And if you can all look at your notes and see, when she expressed her confusion, it was in response to a state's question, not the defense. No appear point. She appeared to have her arms wrapped around her upper torso. Isaiah. So the mom, her arm around her neck and her shoulder, her upper chest, as he described. Now, as you described it, you didn't describe it as up against her neck. No, sir. You were concerned about where it could go, not what you saw. Absolutely. The only person who said that she saw my client strangling her daughter was Zahraa Ali. Now, that's interesting because what I want to do, I'm going to rewind, and I want you to remember Zahraa Ali. In all black, she's got the beige backpack. And what she's really doing is trying to manage Isaiah. She intervenes when he is yelling at Haneen, pulling him away, getting him away from Haneen. She then walks around and walks towards the front, comes back, and then when she sees Isaiah go hands-on with my client, she then intervenes. So you tell me, or you decide for yourselves, as to whether she's actually paying attention to what's happening. I will go back all the way to the point of where my client and Josh Wagner. Now remember how long my client is standing up before she's even down on the ground with her daughter.
Can you indicate the time, please?
Yep. Thank you, Your Honor. It is 2:13:58 hitting play. So there you see Ms. Carter dive into the pack. In front of the bus driver. She's standing over in the far left behind Isaiah. Haneen starts filming. Isaiah begins to attempt to punch. She pulls Isaiah back at 2:14:37. She's holding on to Isaiah. Isaiah disengages from Haneen. She's having a spirited conversation with Haneen. She then walks away. Back to the whole incident. She then confronts Haneen again, starts pushing her. Pointing, turns to her right, looks to her left. Stopping at 2:15:30. Wasn't watching at all. I mean, I don't blame her. There's a lot going on. She's taking care of Isaiah. Haneen is arguing back and forth with her. State also relies on Mary Wagner. This wasn't intentional. I just happened to stop it at 2:15:30. She has now decided to run across the street and start, saying, "Hey guys, knock it off." Everybody who was around there, nobody said that they saw my client strangling. They said, "Yeah, I saw her grabbing her, saw her holding her." Her daughter, to the police at the hospital that night. "My mom was holding me. I was in pain. I had just woken up. I was confused. I tried to speak, but words couldn't come out. My voice was raspy. I wanted my mom to let go of me. I was in pain. She wasn't trying to hurt me. She was protecting me from the chaos." I can't imagine an attempted murder charge where the alleged victim is telling law enforcement that night, "I don't think the person's trying to hurt me. There was chaos. I had just been rendered unconscious from a previous struggle that my mom wasn't involved in." So let's take a walk through the jury instructions. I will be the first to acknowledge, or maybe not even the first to acknowledge, that there is a lot here, okay? Even as somebody who's been doing this, state, defense, the court, there's a lot to this. And the court instructed you that every single instruction matters. There's no one instruction that's more important than the other. Many of the instructions refer to other instructions. A couple of trials ago, I described this as a book, which I think is helpful. If you think of this as kind of, when you read a book, there's an introduction, right? Instruction number 1, it's your duty to decide the facts in this case based on the evidence presented to you during this trial, right? So that's the introduction. Judge talking about, her role. I'm not ever intended to comment on the evidence. If you think I did, don't do that. I don't take that way. How you evaluate evidence, how you assess credibility, lawyers' remarks, objections, evidence. So that really kind of basic stuff. So then we talk about jury instruction number 2. As juror, here's your job. Your duty is to discuss. Number 3, every charge is different, and not a verdict on one charge determines the verdict on the other. Instruction number 4, reasonable doubt. Okay? Everything has its place. So then we get to around 13. We talk about accomplice liability. And then the first one is a 2 convict instruction for Mr. Ali, and that's 15. Okay? So if you're taking notes, you can take notes or you don't have to. But there are 5 2 convict instructions for my client. Attempted murder in the second degree, 2 convict is instruction 16. The assault 2 is instruction 30. Unlawful imprisonment is instruction 35. And I'm going to walk us through some of these. Burglary in the second degree is 46. And violation of the court order is 48. And so we often spend a lot of time talking about those because that is the ultimate roadmap for you as to how you decide, in order, has the state proven beyond a reasonable doubt the following elements? and then it refers to other instructions. So then you get to the end, and then it kind of is a concluding instruction, and it tells you, okay, here's how you deliberate. Select a presiding juror, kind of the order in which you consider things, when you do a special verdict, when you consider a lesser, okay? Now, there will be times where I can imagine a juror saying, well, what about this? The answer to that question, if there is an answer, is somewhere in here, okay? You have every right to ask the court a question and say, you know, as the foreperson would write the question and say, we're asked for the following information. And as Ms. Doan alluded to, we are very limited in the ability to answer those questions. I'm not saying you're not going to get an answer, but very often it will be, please refer back to your instructions. Because we have to be careful to not influence your process and give undue attention to a certain instruction. Or if there's a mistake, it will often be clarified. But if you get a response to say, please refer to your instruction, the answer is somewhere in there. And maybe it's unsatisfying, but that's kind of how this works. Okay, so I want to be conscious of time, so I'm going to kind of walk through the two convict instructions. Turning to 16, which is attempted murder in the second degree for my client. Okay? Now, if there is a reasonable doubt as to any of these elements, you're done. The state hasn't established beyond a reasonable doubt. And Mr. Kading talked about it a little bit, but the reasonable doubt instruction is instruction number 4. You don't need to turn to it, but I'll just tell you. So that's where it talks about the presumption of innocence. The state has the burden. A reasonable doubt is a doubt. It can be singular, for which a reason exists. Okay? So it's not just some doubt that's made up in thin air. You have a reason for it. And your reason can arise from the evidence, testimony, exhibits, or the lack of evidence. Well, how come we didn't hear from this person? We weren't given this, okay? So the question is if you have a reasonable doubt, the state hasn't satisfied its burden. Now, as a principal or accomplice, did she take a substantial step toward the commission of murder in the second degree? Instruction number 11 defines substantial steps. Conduct strongly indicates a criminal purpose. So when she walked up there, was she acting as an accomplice? (13) defines accomplice. Did she aid? More than mere presence and knowledge of criminal activity of another must be shown to establish that a person present is an accomplice. She didn't solicit, she didn't command, she didn't encourage, she didn't request her husband to commit murder in the second degree. Did she aid or agree to aid in his attempt to murder his daughter? Well, the state has acknowledged that there was no plan. There was no, Mr. Ali didn't arrive there with the intent to murder his daughter. So in the seconds that she walked up there, after seeing her husband being punched, she said to the officers, I saw that. As she approached, her husband's on the ground, her daughter's on the other side, there's kids in between. Mr. Wagner, coming from the other direction, had a clear view of Fatima. The state would have you believe that in those mere seconds that she formed the intent to say, wow, I'm going to help my husband kill my daughter, by kind of standing around trying to push Isaiah off, who had just been punching her husband in the head. Or that she, while she's holding her daughter, crying, my daughter, in a voice that Fatima described as sad, and told the police that she was trying to protect her from the chaos. In the state's eyes, that's attempted murder. Ladies and gentlemen, this is why we have juries. It's not her decision. It's not the court's decision. It's not my decision. It's your decision. It's your responsibility to hold the state to its burden, that we start from a presumption of innocence. Constitutionally, we walk in this door and we say that my client has not done anything. What did she do? She ran across a parking lot, through a crowd of kids, said that she could see her husband being punched, not 30 times, not 40 times, towards the end, stood there, as we saw in the video when it zoomed in, kind of with Mr. Wagner. Wagner goes in, frees the daughter. If that's attempted murder, we're all in trouble. If a mother going to the aid of her daughter, checking on her husband, who a mob has surrounded and kicked repeatedly and beat, and there's no evidence that she could actually see her face from where she was standing, that in those seconds it's attempted murder, I submit that it's not. Next is the assault 2. Instruction 30. State has to prove. On or about October 18, 2024, the defendant, Zahraa Ali, intentionally assaulted her daughter by strangulation. Ida Williams. Her arm was around her neck and shoulder, around the upper chest. Would you describe it as up against her neck? No, sir. Were you concerned about what you saw previously was potentially going to happen again? Absolutely. And that's why you intervened. Not because she was being strangled, but you wanted to put her free and you were worried about her. Instruction 35, unlawful imprisonment. Did mom substantially interfere with the liberty of her daughter? That the restraint was without legal authority, and that the defendant knew such restraint was without legal authority. We revert back to instruction 20. And that is the parental discipline. Discipline isn't really, I think, an appropriate term, because you think of it in terms of somebody who's been bad. But in terms of basically, when do you get to hold your child? So physical discipline of a child is lawful when it is reasonable and moderate, and it is inflicted by parents for the purposes of restraining or correcting a child. She's not trying to correct her. I don't even know that she's really trying to restrain her. I think she described that, Fatima described her mom's actions perfectly. She was trying to protect me from the chaos. Wailing, my daughter, my daughter. That seems to run entirely counter to criminal intent, acting unlawfully. The defendant knew that such restraint was without legal authority. Okay, I want to turn to the burglary. And I know I'm going fast, but you guys have been sitting here all day, and I want to be respectful of your time. Okay. Front page of the instructions. State of Washington versus Zahraa Ali in the case number. Okay? This isn't Fatima Ali versus Zahraa Ali. Daughter doesn't bring charges. This isn't Timberline High School, North Thurston School District versus Zahraa Ali. This is the state of Washington, as represented by these two prosecutors, okay? This is the state that is electing to bring the charges, and they are the ones choosing to bring the charges, okay? There are two, we heard about the act or the trespass order that was issued by the vice principal. We can question all day the wisdom of that order, but that order was in place, right? In response to School Resource Officer Howard, I was there basically as a show of force. I handed her the letter, said you can't come to school. She appeared to understand that she couldn't come to school. Okay. And the letter, which you have in evidence, says you could be charged with criminal trespass if you violate this order. If we were here talking about count 4, defendant Zahraa Ali is charged with the crime of criminal trespass, I'd be like, yeah. State has proved beyond a reasonable doubt that she's guilty of trespass. But that's not what they chose to do. They chose to try to, for whatever reason, go for more.
Objection.
Sustained.
So they didn't charge criminal trespass. They're charging burglary. So criminal trespass is the first piece. I can see. She didn't have permission to be at the school. The second piece is that her entering the school or remaining at the school was done with the intent to commit a crime against a person or property therein. Okay? State in their closing said, okay, there's 3 potential crimes that she could have committed while she was there. She could have run in to try to assault her daughter. Really? Do we really think that she was running in there to assault her daughter? The woman who is holding her, protecting her from the chaos, is then going to run into the school and assault her. Isaiah. Maybe she was trying to assault Isaiah. She had no interest in Isaiah. Haneen was upset with Isaiah. You saw her interacting with Isaiah a ton in this melee. She was upset. There was pushing. There was a threat to punch by Isaiah. That was. She didn't care about Isaiah. Her intent to go into that school was not to assault Isaiah. So then the only question is, the third option is a violation of protection order. So this is where it gets interesting. The 2 convict for the violation of the court order in 48. You have the body-worn video, Exhibit 38, from the officer who handed the order to my client. You get to see, and this is the miracle of body-worn video, you get to see what she said. You don't have to rely on his interpretation. He says, she's like, are you with the school? No, I'm not with the school. I'm not a school resource officer. What is this? Haneen comes and you can hear them talk in Arabic. State chose not to translate. They have it on video. They didn't bring in an interpreter to say what was being discussed. And she has questions. And he's just like, well, it looks like Dad, Isaiah Williams, this person is. Yeah, I know. So it just basically, it says, and this is what he's telling her. Don't contact him. Don't call him. Don't email. Don't stalk him. I don't even know if he said stalk, but he said, there's no mention of school. He never tells her school, never tells her 1,000 feet. It's a little curious when the state puts up the exhibit and says, oh, it's a really simple document. We know from Fatima, she says, yeah, Mom speaks English, not nearly as well as Dad. Does she read English? Nope. She gets handed a document, not written in Arabic, doesn't use a language line, doesn't say to Haneen, hey, look at paragraph 4 on page 4, whatever the number is, and make sure you understand that this could be bad if you go to the school 1,000 feet None of that conversation happens. State, for whatever reason, never called Haneen to say, what conversation did you have with your mom? There is zero evidence. All that you can know is that she was said, don't have contact. So now we go back to the burglary. That the entering or remaining was with the intent to commit a crime against a person or property therein. Did she run into that school to violate? I'm going to run into that school to violate, with the intent to violate a protection order against Isaiah. She wasn't running in there to have contact with Isaiah. She was running in there, my daughter, I saw my daughter run in here. I had it on here, but you guys have it. You guys can watch the video from Timberline High School. She is in there for seconds. She runs in. You hear from the counselor. She gets in, closes the door. She could hear her yell, my daughter, where's my daughter? I know my daughter went in here. What does she do? She lingers for like 2 seconds, turns around, and walks out on her own. She wasn't being non-compliant. She then goes around to the other side. The principal's like, no, we don't know what he says, but we can kind of surmise. Like, no, go, can't be here, go. So in order to convict her of burglary, you have to conclude that she has the intent to commit a crime inside. Not that there was some order that she didn't understand written in English that said she couldn't be within 1,000 feet. That she had the intent to do something other than find out where her daughter is. It's just interesting. Picking up themes. The state was constantly asking. She was more concerned about her husband. Really? She's holding her daughter. Her daughter gets ripped out of her hands by Isaiah. She runs, and she kind of shuffles towards the school. Somebody who is more concerned about her husband who's just been kicked, and she left him behind, goes to check on daughter, goes into the school. Where's my daughter? Where's my daughter? And the question is well, did she ask her condition? Of course she did. She's trying to find her. So then we go to the final crime, the violation of the court order. Did she knowingly violate a restraint provision of the order prohibiting contact with a protected? I'll be the first to confess, there's a 1,000-foot distance provision in there that if she understood it, she violated it. She wasn't supposed to be there. What evidence is there that she understood it? You hand me a protection order written in Arabic. I don't know what it says. What did she know? She knew that she couldn't call, she couldn't have contact with Isaiah. You watch that entire video. At no point does Isaiah say, I'm having a conversation with her. At no time does she reach out and try to have contact with Isaiah. Yeah, she was there. She stayed in the car. She stayed away. Daughter got in trouble. She ran over to her daughter. She went to the school to check on her daughter. She never talked to Isaiah. She never had any contact with him. No. State's going to be like, well, that's preposterous. Really? Is she there to have contact with Isaiah? She's there for her daughter. Sitting in that car, October 18th. She knows she's different. She's from a different country, speaks limited English, has limited success with navigating the school. She tried to do what was best for her daughter, tried to get her transferred to North Thurston. Couldn't imagine a scenario where her daughter went to school, running away from a school that she could never even go to. She tried to get in-person school for her and was turned away. Went to the police, tried to get help, didn't work. Went to the school to try to intervene, wasn't told the condition of her daughter, wasn't allowed to see her daughter. Her husband was taken away. No idea that she would have to defend herself and her approach to her daughter and her approach to her husband, and that under a convoluted set of facts and allegations would be accused of attempted murder, assault in the second degree, and unlawful imprisonment. All because, as her daughter described, she was trying to protect her from the chaos. She went into the school to look after her. On the one hand, the prosecutor says she doesn't care about her. She cares more about her husband. But then when she runs into the school to check on her, she picks up an allegation of a fourth charge, a burglary. That could have been a criminal trespass, but no, we're gonna defend.
Objection, Your Honor.
Sustained.
Has to defend herself against a burglary in the second degree charge. We talk about unconscious bias. My client is different. You can't allow yourself to look at her any differently and reach a decision because she's different. The decision has to be the same, whether or not her child grew up from kindergarten to junior year, played sports, was in the school, the mom was the head of the PTA. She was the head of the PTA. She did exactly like my client did. I don't think she would have been here. And that has to be concerning for each and every one of us. And that's what I love about our system. We have a presumption of innocence, and it is designed to safeguard, protect clients who may be different, to be a check on the government, and to say, no, not this time, and not this case. If you consider the facts, the circumstances, and the law, there is one verdict that applies for each and every one of the counts. My client is not guilty. I think we can all agree that this is a tragedy, and we certainly could have done things differently, but that doesn't make this a crime. Again, I appreciate you being here.
Members of the jury, we're going to do a brief stand-up